Ms. Dominguez, would you please begin the announcements?
Yes, Your Honor. Corinne Dominguez for the department.
Jennifer Harris, attorney for the respondent mother, Ms. Enriquez. She's present. Ms. Enriquez, can you please unmute and announce your name?
Yes, I'm unmuted. Bianca Enriquez. Alana Pierso, attorney for Mr. Robles and unknown father, who are not present, and I'm not ready. And I don't know that they've been served, Your Honor.
Anna Swallow, attorney and guardian ad litem for the child, ready?
Yes, I'm Deidre Gavlik, child protective investigator.
All right. Do we have service on Mr. Robles? I don't show in my system. No?
We don't yet. We've got a potential address for him, so we'll be seeking to serve him. He is an alleged dad. So as soon as we can complete that, we will.
All right, then I'll grant Ms. Pearsall is not ready. Won't make any orders as to Mr. Robles today. Do the parties have an agreement as to the mother?
Yes, sir.
What are the terms and conditions of that agreement?
The department will have temporary managing conservatorship. The mother will have possessory. The child to remain in current placement unless there's an emergency or order of the court. We'll have the 262.013 language. We're agreeing to an FGC and service plan. And then one supervised visit per week for 30 minutes with the child. And we would waive or suspend child support and medical support until further order of the court. And we would waive or suspend child support and medical support until further order of the court.
After you said the child was to remain in the current placement except for emergency or order of the court, there was something in between there and the supervised visit. What did I miss? What was next on the list?
We have 262.013 language.
I got that.
FGC and service plan.
Okay, then I got it all. All right. Okay, Ms. Gavlik, you've heard the agreement of the parties. Do you believe it's in the best interest of the child or the children? No, the child, excuse me.
Yes, Your Honor.
All right, and you believe the current placement is safe and appropriate, meeting the child's needs?
Yes, Your Honor.
And you believe that the department made all reasonable efforts in this case to avoid a removal and to return the child home?
Yes, Your Honor.
You believe the circumstances of the case prevented keeping the child at home?
Yes, Your Honor.
It necessitated a removal?
Yes, Your Honor.
Is everything that was in your affidavit when you filed it, to your knowledge, still true and correct?
Yes, Your Honor.
Thank you. Do the parties stipulate as to the reasonable efforts made by the department in this case?
Yes.
Yes, Judge.
Yes, Your Honor.
Ms. Harris, is that your understanding of the agreement?
It is, Your Honor. I would ask for the caveat, though, that as far as the weekly visits, that we can increase them upon agreement.
And Your Honor, I did forget one bit of language regarding the placement. I believe there was language regarding giving 24-hour notice that the visit will occur. If we don't get any notice, then there won't be a visit.
Okay. In 24 hours?
Yeah, let me make sure, Judge. Hold on.
And Judge, I can speak to that.
Go ahead.
I would request that the mother be required to confirm her visitation 24 hours in advance. And then also, I do not want the child to have to travel, so I would like for the visits to occur where the child lives. Right now, the child and the mother both live in Uvalde.
Okay. Let me go back to Ms. Harris real quick. Ms. Harris, was your concern addressed? To increase
Yes.
as agreed, right?
Yes, just as agreed.
Okay, go ahead, Ms. Swallow.
I would also like to see the records, the birth records of the child. Right now, there's no referral I have seen for developmental pediatrician, and I think that's quite possibly in those birth records, and I don't want it to be overlooked. And if it's not in those birth records, it needs to happen considering the circumstances by which this child was born. So I don't know if that's something the department can do. They have access to those records. I do as well through the hospital. It's probably going to be easier for the department to get those and distribute them to the parties.
Is there any objection from the department to get the birth records?
No, sir.
All right. Ms. Gavlik, do you think that's going to be an issue?
No, sir. I can work on that.
Okay.
And Judge, if there is a referral to a developmental pediatrician, I imagine it's coming up here real soon. Sometimes they make that appointment in the hospital. So if we could put a time frame on that, I know mom has access to those records as well.
You want a time frame on when the record should be distributed?
Right. So I think within the next week, mom can call up there and get a copy sent to her.
Okay. All right. Otherwise, is that your understanding of the agreement, Ms. Swallow?
Yes, Judge.
Okay. And Ms. Pearsall is abstaining from this agreement. Ms. Enriquez, I need you to unmute, please. Okay, you're already unmuted. Did you hear the agreement?
Yes.
Is that the agreement you made?
Yes.
Did you have a chance to discuss it with your attorney?
Yes.
Do you understand what's expected of you?
Yes.
Are you asking the court to approve your agreement?
Yes.
Were you forced into this agreement in any way?
No.
Were you made any promises or any inducements to get you to agree to it?
No.
Okay. Are you able to afford an attorney in this case at this time?
No, sir, I'm not.
Are you able, do you have anything that you could sell or anything that you could liquidate that would allow you to pay for an attorney?
No.
All right. Are you receiving any type of governmental assistance at this time?
Yes, I get food stamps.
All right. And for the purposes of this case, the court will find that Ms. Enriquez is indigent at this time and will continue Ms. Harris in her appointment. Anything else from anyone before I make a ruling?
And Your Honor, as far as we know, there is no Native American heritage.
Oh, no, there was Native American heritage. My dad told me yes, yesterday after I talked to him. He said it'd probably be like 35%.
All right, so we have potential Native American heritage then.
Yes.
So here's how that works, Ms. Enriquez.
Okay.
You are responsible for providing documentation to Ms. Gavlik. Any kind of proof that you have, names, addresses, phone numbers. She's going to work with you to fill out paperwork to put the department on notice and provide them with the information they need to determine whether or not your child actually has Native American ancestry, and then go into a process of determining what it is. And if there is Native American ancestry that can be verified, then contacting that tribe and putting them on notice of this suit. If you don't provide the information that Ms. Gavlik needs, then there's a very good potential that she's not going to be able to figure out if Jayla has Native American ancestry or not. Okay.
Okay.
So you have to work with her on that.
Okay.
Okay. Then for the purposes of this suit, we're here for an adversary here today. Court fine.
I'm sorry, can I ask Ms. Enriquez a couple of questions?
Sure.
Ms. Enriquez, do you have any information about Mr. Robles?
I just had his first and last name. That's all I had.
You don't have his date of birth?
I don't have his date of birth, and he doesn't have a phone. And I don't have his address for where his grandma lives.
Okay. Do you have him on any social media or know any of his social media accounts?
Yeah, he blocked.
Okay, but do you know what it was before he blocked you?
Oh, yeah. Oh, so it's James. So it's James.
Okay.
And then,
Hang on. Let's put this in the chat. We're on YouTube. Ms. Enriquez, can you see how to put something in the chat function?
it says chat. Okay, yeah.
Type it in there, please.
Okay.
Okay, and can you just indicate what it is as well as what kind of social media it is, whether it's Facebook or Instagram or what it is?
Yes.
And other than Mr. Robles, who else might be the father?
That's all.
Okay, there's no other possibilities.
No, ma'am.
Okay, and you said he has a grandma. Do you know how to contact his grandma?
No, but all I know is, that's where he stays in Batesville with his grandma.
Okay, so he has a grandma somewhere in Batesville, Texas?
Yes.
Okay, do you know the grandma's name?
No, I don't. But he's had CPS cases in the past, so I know, they should be able to find his address, I think, from history, from his past history with CPS. I don't know why they haven't been able to, because he had a CPS case like 2 years ago with his other kids.
Do you know the name of his other child with whom he had a CPS history?
Yeah, Alexis Garcia. That's his the mother of his other kids.
Thank you. No other questions, Your Honor.
For the purposes of the adversary hearing, the court finds that there is potential Indian child heritage in this suit. I'm going to order the department to work with Ms. Enriquez, and I'm ordering Ms. Enriquez to work with the department to determine when and if there is any actual ICWA in this suit that we need to take care of and put a tribal on notice. Court finds that the alleged father, James Robles, has not been served yet. The court's not making any orders as to him today. Court finds that the parties have entered into an agreement, and it's in the best interest of the child for the Department of Family Protective Services to be named the temporary managing conservator of the child, and for the mother to be named the temporary possessory conservator of jailer. Court finds that the current placement is safe and appropriate, meeting the child's needs. The child is to remain in that placement and not be moved unless there's an emergency or a further order of the court. Court will grant mom, Ms. Enriquez, one supervised visit per week for 30 minutes, subject to an increase upon agreement of the parties based on mother's engagement. Mom needs to confirm 24 hours in advance as to whether or not she's going to take the visit. Ms. Enriquez, if you do not confirm 24 hours in advance, you will not have a visit.
Okay.
Don't call 20 hours in advance to confirm. Don't call 23 and a half hours in advance to confirm. 24 hours in advance. All the visits are to occur in Uvalde at this time. Court will defer child support and medical support until further order of the court. Court orders the parties to hold a family group conference and develop family plans of service that are narrowly tailored to address the concerns that brought the child into care. Court makes this finding based on or with the contingency of a 262.013 language inserted into the order, in that by entering into a voluntary agreement with the department, mom is not admitting any of the allegations in the affidavit. I'm going to order the department to get the birth records to all parties within the next 7 days. Court makes the finding that there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession. And for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal. And reasonable efforts have been made to enable the child to return home, but there's a substantial risk of a continuing danger if the child is returned. We'll be back for our status hearing October 3rd, 2024 at 10:30. October 3rd, 2024 at 10:30. So Enriquez, I have to admonish you that the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violent, and drug-free home for your child. In the event you cannot do that within 12 months, your rights to your child are subject to further restriction, as they are now, or termination. Ms. Dominguez, is there anything I failed to address?
Did you address the child support, Your Honor? I'm sorry.
I said I deferred child support and medical support.
Thank you then. No, sir. Everything's good.
Okay. All right. Nothing further. Thank you all for your time and your service. All parties are excused.
Thank you.
Good luck,
Thank you,
Ms.
Judge.
Thank you, Your Honor.
Thank you.
Yes, ma'am.
My client forgot that we had court this morning and she's in Austin. She's available to participate, but she's in spaghetti straps. We've had the status hearing. We're all good. I don't know if you want her to participate anyway, or let her skip this one with me appearing.
Sorry, I didn't get that. I'm fine. If you're comfortable without her appearing, that's fine. Or leaving her video off, that's fine, as long as you're comfortable with it.
Okay.
If she wants to come on, I'll allow it this time, but if she would rather not, that's fine.
She apologizes, Your Honor. Thank you for understanding.
I appreciate it, and thank you. I appreciate that. Does anybody know where Miss Pearsall is? Has anybody heard from her? Was she in trial, or is she just late?
I don't know, Judge, but I'll try texting her.
Thank you. I don't have a coordinator this week, so I would appreciate it. Okay. We're going to go ahead and call the case, and hopefully she rolls in here.
No, Your Honor.
Thank you. With that, then, Ms. Dominguez, would you please begin the announcements?
Yes, sir. Corinne Dominguez for the department, Your Honor.
Christy Canal, Permanency Supervisor with Belong.
Ontropolis, Permanency Specialist with Belong.
Good morning, Your Honor. Jason Jett. I am here on behalf of Anna Swallow, and she represents the child.
Thank you. Is that your client that just logged in on the Motorola, Ms. Harris?
I believe so, Judge. I told her to keep her screen off.
That's fine. Ms. Enriquez, can you please unmute and announce it's *6?
Okay, it's unmuted. Sorry about that.
Okay, I just need you to state your name for me, please.
Bianca Melinda Enriquez.
Okay, thank you. Anyone who's not an attorney or will be giving testimony, please raise your right hand. Okay, I don't have Ms. Pearsall here yet. Did you hear anything back, Ms. Harris?
Not yet, Judge.
Okay. Did we ever get service on Mr. Robles, Ms. Powell?
No, sir. I've located him, but no service on him.
Okay. Well, I'm going to go ahead and move forward. I'm not going to make any orders as to the father, and I'll excuse Ms. Pearsall from this hearing anyways, because it doesn't make a difference if she's here or not, unless she's got information that I don't know. But we're here for a status hearing. When we were here at the adversary, there was a discussion of some potential Indian child heritage in this case. Ms. Powell, have you heard anything else about that or explored that anymore?
Yes, at the FGC, there is no Native American heritage.
Okay. Definitively ruled that out?
Yes.
Okay. And then again, Mr. Robles is still not served. He's an alleged father. And for the record, Ms. Pearsall is not present, but I'm going to move forward because we don't have service on the father anyways. Maybe Mr. Brandon is supposed to be standing in. Maybe he just did an oof. We'll see. Okay. Did you all designate a permanency goal at your family group conference, Ms. Powell?
Yes, we did. And unfortunately, I apologize to the court. The status court report was done before the FGC. Going forward, the permanency goal would be related adoption with a concurrent goal of family reunification.
Okay. Mr. Brandon, are you here for Ms. Pearsall?
Yes, Judge, I am. I'm sorry. I was having connectivity issues at the building that I went in. I finally found a spot, but yeah, I am covering for her, and her notes indicated she wanted me to announce not ready on her clients, and yeah, that was what her note said, Judge.
Well, your job is really easy because I already granted sua sponte not ready because her client hasn't been served. So
there we go. Okay.
Thank you for being a
Sorry,
one body.
I was
I
late.
appreciate it. It's okay. We
Yeah,
moved
sorry, I was
forward.
sorry.
I didn't know if she had coverage or not, and I knew her client wasn't served, so we just moved forward. So it's fine. But thank you. Is the current placement of the child, Ms. Powell, safe and appropriate, meeting the child's needs?
Yes, it is.
And what county is that placement in?
Uvalde, if I'm saying it correctly.
Is it in the child's best interest to continue there?
Yes, it is.
All right. And what date was that placement made?
She was placed on August 26, 2024.
Okay. And I know Jayla is very young, probably hasn't had a dental yet, or probably doesn't need one yet, but is everything else up to date?
Everything else, all medical is up to date.
Any concerns?
Not at this time.
Any developmental or noticeable delays at this time?
Not at this time, but they are keeping an eye on her.
Has she been assessed?
I do not believe that has been set up, but it can be set up going forward.
Okay. Yeah, I'll probably order that to be done just to make sure. Okay. Is the current visitation schedule with the mother appropriate?
Yes, sir.
And are the visitations themselves with the mother appropriate?
I've observed one visit so far, and it was appropriate.
You're not asking for any changes to visitation today?
Not at this time.
Okay. Has mother asked for anyone else to be studied at this time?
Not at this time.
And you all held a family group conference and developed family plans of service that were narrowly tailored to address the concerns that brought Jayla into care?
Yes, sir.
Were they narrow, or were they best interest of the child for the court to make them orders?
Yes. Yes, sir.
Are they in the file?
We actually had to redo those orders once we were in the FGC. Miss Enriquez will be working abbreviated services, so those will be filed today to amend the ones that were already filed.
Okay. And did Miss Enriquez have the opportunity to participate in the creation of the plan?
Yes, sir.
After the plan was created, did she have the opportunity to review it and sign it?
She has not. That she actually didn't make the visit yesterday. That was the day she was to sign, but we can get that done as well.
Just out of curiosity, if the plan was created there, why did she not sign it when she was there?
Because the plan was created on paper and I had to go back and revise them.
Okay. And could you briefly set forth the services that Belong is asking the mother to complete in this case?
Yes, the services we're asking her to complete are individual counseling, random drug testing, and an OSAR assessment.
Have you discussed these with her?
Yes, at the FGC.
Do you believe she has an understanding of what she needs to do first?
Yes.
And have any referrals been made yet?
It will be made today.
Do you believe that at this time Belong has made all reasonable efforts to make a reunification? I know it's early in the case, but do you believe that everything's been done?
Yes, sir.
And is it safe to return the child to the mother at this time?
Not at this time.
Has she addressed all the concerns appropriately at this time?
At this time, yes.
Which she has addressed the concerns or she has not?
She has.
Okay, so why isn't it safe to return the child to her?
She would like the child to be adopted.
Okay. All right, now I think I understand. And do you think it's in the best interest of the child to remain in the temporary managing conservatorship of the department at this time?
Yes, it is.
Okay. For whatever reason, I didn't get a copy of the report, so that's why I had so many questions about the long-term plan. I just hadn't seen it yet. Ms. Dominguez, do you have questions for Ms. Powell?
Just a few to clarify, Your Honor. So in the report, it said the mother and father had not been communicating with you all. When did that change? When did they start cooperating?
I located the father last week, and it was about at the FGC, shortly before the FGC. So shortly before the 24th, we had the wrong telephone number for Ms. Enriquez.
Okay. Now you say she wants to have the child adopted. Why is she doing any services if that's the case?
She would like to continue visitations.
Okay, thank you. And do we have any home assessments done yet, or are they all still pending?
It is pending. It's been turned in for the home study. I believe I turned that in on the 10th of September. So we're waiting for that information to come back.
Thank you. And that's on the current placement?
Yes, ma'am.
Thank you. Nothing further, Judge.
Ms. Harris?
Ma'am, it's been Ms. Enriquez's position that she wants placement to adopt since that's been her position since before the child was born, correct?
Correct.
And the department or Belong is good with the placement?
Correct, yes.
Are there any concerns that you think might be barriers to adoption eventually?
Not at this time.
And you had the wrong phone number for her, but Ms. Enriquez has been cooperative with Belong in the department all along, correct?
Yes, she has.
And does it seem like this family and extended family has a plan for how this ends up in the long run?
Yes, ma'am, they do.
And is the placement related to this child's sibling in some way?
Yes, ma'am. Miss Barber is the paternal aunt of Jayla's half-sister.
And why is it important for Belong to stay involved as opposed to dismissing the suit and just letting them pursue adoption?
It's to ensure everything is going fine with Jayla and to assist them in the adoption process.
And as you said, the mother is working services so that she can demonstrate she is safe to be around her daughter in the future, correct?
Correct.
And is it this family's plan for the child to know who her mother is and have her mother be around her if she's safe and appropriate?
Yes, it is.
No further questions, Judge.
What's the termination timeline?
The dismissal for the case?
Well, I mean, I guess my questions kind of revolve around.
I can answer that if you like, Judge. It's a legal reasoning.
Please.
Because there is an alleged father involved in the case and he has not been served, my client does wish to sign a relinquishment and assist with pursuing the adoption. But because there is an alleged father out there, we believe it's important for her to remain involved until we've been able to resolve that issue.
Okay, that makes perfect sense. I just wanted to make sure that I understood it. You know, well, I'll hold off on any of that. Anything from you, Mr. Brandon?
Nothing, Judge.
Okay, Mr. Jett.
I don't have any questions for Ms. Powell. Just a couple of things here, Judge, if I may. I know Mr. Brandon, Ms. Pearsall's client, hasn't been served, and I understand we can't make any orders about him. Just ask that he appear before any visitation is given for him. Once he does appear, we'd like a DNA. I think you can't order that now just yet because he's not fully in this case. The other thing was, Judge, and you mentioned it, that you wanted this developmental assessment, and we definitely want that based on the short history of this little girl's life. And Judge, we had a question. I believe there was a discussion at the adversary hearing, the 262 hearing, about some records of the birth, and wanted to know if those had been received. Ms. Swallows indicated she doesn't have them, wanted to know if anybody else did and if we could get those circulated.
That was on my list of questions that I had to after hearing everything. I've got a note from that September 5th hearing that the department was supposed to get the birth records to all parties within 7 days, but it doesn't sound like that happened. Ms. Powell, do you know what the deal with the birth records is?
They've been requested. We have not received them.
Okay. Do you have a timeline? Did they give you any kind of idea how long it would take?
They did not, but we can send in another request.
Why don't we put it in the order?
Okay.
Ms. Dominguez, that the court's ordering that the birth records be distributed to the parties no later than October 15th. And that way, Ms. Powell, you can take that order and you can send it over, send a certified copy to the agency and let them know that you're under a timeline, under a court order to get those records. I don't know that we're dealing with BBS here.
I don't know the vital statistics.
Yeah, if it's vital statistics, then I don't know if it's going to make a difference, but that's the best I can do at this point. Is just order that they be submitted to the court within 15 days in the parties, and then hopefully that'll give you the ammunition you need to get them to move faster on that, but we'll see.
I don't know if we're getting pushback, Your Honor. We can send like a separate order to them, ordering the release.
Well, it's not pushback that it's just they're slow. Okay. If it's vital statistics, I mean, we waited months and years for things that we shouldn't have waited months and years for. Okay. The only way to deal with it is to let them know that we're on a timeline and we need the records now. So,
and Your Honor, my client's willing to assist in any way possible, but you and I both know that nobody's going to help her out when she's in a CPS case.
No, I understand. Let me make my orders first. Is there anything else that you want to add, Ms. Roden?
Yes, sir. Just that we've been out, we've seen Jayla in her home and we've met with the caregiver. We're also able to attend the FGC just because there's been a lot of discussion about her needs. She was born premature. The placement did have some concerns with just had a continuous wet vocal sounds during feeding, some congestion that hasn't gone away. But just to kind of reassure the court, she does have, and I could be wrong, but I believe today she has her telemed with the neonatologist that's still following her. So there is her doctor, because she was premature, that is still following her. She has an in-person, I think, in October. And I think that might be our best bet to ask for that developmental recommendation. I think if Miss Baber can talk to the neonatologist today about the referral for the developmental pediatrician, I think rather than ECI, just because of the issues with the birth being premature and some of the conditions of her birth, I think that a developmental pediatrician rather than like an ECI evaluation would be more beneficial for Jayla. So we'd like to see that happen. And we did discuss that with Miss Faber, the placement, when we visited this week.
Okay, so you want me to order a pediatrician evaluation, developmental pediatrician evaluation, which would be dependent upon a referral, correct?
Yes, I think we could get that from the neonatologist that she sees today.
Okay, because I mean, I can obviously order the evaluation to be done, but that referral process out of my hands. So hopefully that's how it'll go. Okay. For the purpose of the status hearing, court finds there's no any child heritage in this case. Court finds that the father, Mr. Robles, who is alleged has not yet been served. The court will only make an order as to the father that he must appear before the court prior to any visitation or contact with the child. Court finds that the current placement of the child with a relative in Uvalde, I know it's kind of a tenuous relative bond here, but that's what I'm calling it, in Uvalde County is safe, appropriate, meeting the needs of the child and the child's best interest to continue. Court finds that all her medical is up to date. There's no delays this time. I'm going to order that there be an evaluation by a developmental pediatrician. Again, I make that order knowing that I have no influence over the referral process. So however that needs to happen, it's got to happen. If y'all run into a problem and you need another order, something clarifying, let me know. Court finds that the current visitation schedule is appropriate, that no other family members have come forward to be studied at this time. Court finds that parties held a family group conference and created family plans of service, which were narrowly tailored to address the concerns that brought the child into care. Court finds those orders are in the best interest of the child and that the mother participated in the creation of the plan. She has not yet signed it, although she did review it. Let's make sure she gets a signature on there. Court finds that despite any reasonable efforts to reunify at this early stage, it's still not safe to return the child. The mother has addressed her concerns. Unfortunately, her intention is to relinquish. Now, let me talk about that. It's best interest for the child to remain in the temporary managing conservatorship of the department. I'm just concerned about how long we're going to use this as a resource for something that could be privately done. So I understand the concern for keeping mom involved, and I don't have any issue with that. But if I'm going to trust the attorneys that appear before me all the time, that if this gets to the realm of, this is no longer a protection issue and it's a private issue, I need to know, because we got to make sure that I'm staying within the scope of what these cases are for. I support it 100% if this is the way things need to go, but it needs to happen fast. So we need to get that gentleman served ASAP. We need to find out what he wants to do, and then we need to go from there. So in that sense, I'm going to order that the court have an update on what's happening with this case by November 1st. I want an update to the court by November 1st as to the status of this case and service on the father and intention, so that we know what's going on. Our next hearing wouldn't be until January 2nd, 2025 at 10 a.m. January 2nd, 2025 at 10 a.m. I still have to give the admonishment that the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to restriction or termination. The last thing I want to say is, Ms. Enriquez, if you change your mind, you need to make sure everybody knows that. And you need to make sure your attorney knows that. Because you have legal rights in this case. But, you know, I don't have any problem supporting this plan if it's what you want, but you've got to know what you're doing, and you've got to make sure that you have all your answers and everybody knows exactly how you feel about it. Do you understand? It's *6 to unmute. Ms. Enriquez, can you hit *6 to unmute for me, please?
Okay. Oh, sorry. Can you hear me now?
Yes.
Okay. Yes, it's most definitely what I want.
Okay. Just make sure to continue to communicate with Ms. Harris, all right?
Yes, for sure.
Okay. Anything I failed to address, Ms. Dominguez?
No, sir.
Okay. Thank you all for your time and your service. Mr. Jett and Mr. Brandon, thank you both for standing in. And if nothing further, all parties are excused. And all in the 38th Judicial District. You're welcome. That concludes County, Texas. Court is streaming from Kendall County. Are there any objections?
No objection.
No, sir.
Ms. Dominguez, would you please begin the announcements?
Yes, Your Honor. Corinne Dominguez for the department.
Daniela Ramos, caseworker.
Anna Swallow, attorney and guardian ad litem for Sarah and Nate. I'm ready on the permanency hearing after final order, Judge. I'm also ready on my motion for the court to appoint a guardian ad litem in this case. For Sarah. Sorry.
Jill Roden, Tri-County CASA.
Anyone who's not an attorney or will be giving testimony, please raise your right hand.
And Judge, if I may, I'm sorry. Could we address Sarah's portion of the case first, and then she be dismissed, and then we'll go into the rest of the case?
Yes.
Thank you.
That's what we usually do. It works out. Okay. So we're here on a permanency review after final order. I know Ms. Swallow has a motion filed, so I want to give that the requisite time it needs. So I'm going to kind of sum up the basics here. Ms. Ramos, Sarah is still in the same, look at the name of it here. The name of it is escaping me. I've got the report right up here. What is the name of her placement?
Unity Children's Home.
Unity Children's Home. Okay. And I know we've got to do some discussion about that, but as of right now, is it safe and appropriate meeting her needs?
For the most part, yes, Judge.
All right. But we do have concerns about whether or not it's in her best interest to continue there, correct?
Correct.
She's up to date on all of her checkups.
Yes, Judge.
Her medication review is up to date.
Yes, it is.
Her educational needs being met.
Can you repeat that, Judge?
Are her educational needs being met?
Yes.
What grade is she in?
9th grade?
Is she on grade level?
Yes.
All right. How are her grades right now?
I haven't been able to review the latest. She did state that she is passing at this time, all her classes.
Okay. Well, I know the school year just started, so. I think those are the basics for her at this point in time. Tell me why you believe that she might be better off at another placement.
Judge, she did have already 2 hospitalizations, the last one being July, the 25th. She continues to have outbursts at her current placement. She has been aggressive towards staff and other children. This week, she did state that she has been doing better. However, the placement has been giving us time to search for a different placement that could better suit her needs. Per the last court order, we still have in place to search for an inpatient. However, she does say that she refuses to go to an inpatient treatment center. I reached out to the well-being specialist, the mental health specialist, I'm sorry, and she did state that she's able to refer Sarah to intensive outpatient. However, this is done through video calls. So I don't know how affected that could be, given the situation. But I did ask that she be referred to it.
The outpatient?
Intensive outpatient, yes, but it's done through video. Also, Sarah did state that she wants to be closer to the San Antonio area. So that's another thing.
Okay. Ms. Dominguez, before you ask any questions, I guess it would really just be the department and also have some input on it, but do you have any objection to Ms. Swallow's proposal that the court remove her as guardian ad litem and then appoint Ms. Savage as guardian ad litem for Sarah?
I don't have any objection, Your Honor.
Okay. Ms. Roden, do you have any issue with it?
No, sir. I think having an extra person involved in the case may be beneficial.
Okay. All right, then, Ms. Dominguez, if you want to question Ms. Ramos about anything related to the permanency hearing as it pertains to Sarah, if you have anything.
Yes, just a couple of questions. I saw in the report that she doesn't want to go to school. Can you tell me what that's about?
Well, she has been attending school regularly now, since she's been in this placement. However, she does have incidents there at school still.
Okay, and that's incidents of not attending or incidents behavior wise?
Behavioral wise, while she's at school.
Okay. Now, you said that the last psychiatric hospitalization was July 26th. Is that the correct date?
Yes, July 26th.
Okay. And that there had been another? When was the one prior to that?
The one prior to that was June the 6th.
Do you happen to know what were the behaviors?
It was primarily aggression and having a hard time regulating.
Okay. What other placement would it be if it's not an RTC? Would it be the inpatient?
Correct.
Okay. And this placement is going to accommodate us while we secure another placement for her?
I believe they're working with us until we are able to get her a different placement, yes.
Okay. Thank you. Nothing further, Judge.
Ms. Swallow?
Thank you. Ms. Ramos, do you know why Sarah is opposing an inpatient facility?
She does state that she doesn't want to be in a hospital setting.
Okay. And the potential inpatient facilities that the department is exploring, are they hospital-like settings?
They are a hospital. However, the bedrooms are not like a typical hospital setting, if that makes sense. But it is a treatment center, sort of like a hospital.
Okay. She's currently at a what seems to be a lockdown facility to an extent, correct?
Correct, yes.
Is there any way that Sarah could view these centers so she could have an opportunity to know what she's actually declining?
Yes, so we do also the interviews, and they are actually able to explain and show her pictures, which is the same situation we were dealing with before she went into New Life, in which they showed her pictures. I could actually ask to arrange for a visit to these placements. However, I'm not sure how open they would be to having her go, but that could be something that we look into.
Okay. Because she's, correct me if I'm wrong, is she refusing the interviews?
At one point she did say yes to an interview. However, she wasn't engaging in answering the questions or her asking any questions in regards to the placement.
And based on your experience and knowledge in child welfare, and specifically with this case and Sarah, do you believe that stems from mental health?
Correct.
So we're in a situation where we have a child that needs mental health. Her mental health needs to be addressed. However, she's making the decisions on whether or not we can provide her that appropriate care. to address those mental health concerns.
Yes.
So we're stuck in a loop here, are we not?
Yes.
And why is it that, strike that, are these interviews a requirement of these facilities?
Correct. So they do base their treatment based on what the needs of the child are. And the children need to basically be in agreement to participate in this treatment so they know how long they will be there, basically.
So if I'm understanding this correctly, if you have a child that says, I'm not in agreement to go there, the department is just going to say, okay, and then what happens?
Well, the placement basically refuses to have the child placed there.
Have we tried?
Yes.
So she has had potential interviews with all of the potential placements that she could go to.
She did have the interview with Riverview, which is the out-of-state program, and this is an inpatient, as well as Bayview, which is in Corpus.
So she had an interview with Bayview too?
Yes.
When?
Back in December, I believe. No, I'm sorry. This was while she was a TP at Unity.
Okay. So if I'm understanding correctly, your testimony is that she has had interviews at both of these facilities already in the past.
Yes.
And both of these facilities declined to admit her in the past.
Yes, based on her not wanting to participate, yes.
So did she or did she not have an interview with Bayview?
Yes, she did.
And Bayview told you we cannot accept her.
Yes.
And same with Riverview.
Correct, yes.
Have you attempted to reach out again to see if they would be willing to set up new interviews for Sarah?
Well, what they did tell me is that I would need to discuss this with her, and this was the person that connects us to these placements. It's a different department within the state. And they did mention that I would need to discuss this with her and that she would need to be in agreement for the treatment.
Okay, and does she understand what that treatment would be?
I have talked to her about it. I'm not sure that she understands everything about it.
Do you think providing Sarah with more information would be helpful for her and in her best interest during this process?
Yes.
Because telling a child you need to accept the treatment, if she has so much mistrust for every single adult in her life, every single person in her life, do you think it's reasonable for her to be hesitant for that, considering all that she's been through?
Yes.
So we need to help her understand what that treatment would look like.
Yes.
And we need to help her understand that these programs are not indefinitely. It's a certain amount of time, correct?
Correct.
So there's lots of facts here that we could supply Sarah that would help her feel more supported in her decision.
Yes.
Now, let's say by chance that Unity does end up giving notice, then what happens next?
If there are no other placements, that we would have to bring her into CWAP in Laredo.
And is that a concern?
Yes.
Why is that a concern?
Given that an RTC is not able to meet her needs due to the aggression, it would be a concern having just two people look after her here.
And her aggression, does it include self-harm?
Yes.
Does it include destruction?
Destruction of property, yes, too.
Does it include volatile outbursts that cycle for hours?
Correct.
And screaming?
Yes.
So do you think CWAP is equipped to take in Sarah?
No.
Okay. Thank you. I pass the witness.
Anything else from the department?
No, sir.
Okay. Ms. Swallow, anything else as it pertains to Sarah?
Just to report to the court, Judge.
Go ahead.
Judge, I would request that the court grant my motion, taking me off as Sarah's guardian and appointing Ms. Savage as her guardian. I think it's clear that, you know, what Sarah wants and what is in her best interest just completely conflict right now. So I need someone else on the case so I can advocate solely for what Sarah wants, and then the guardian ad litem can focus on best interest for her. I was able to visit Sarah, I don't know, maybe 2 weeks ago, and it was not a very good visit. And I think that Sarah is struggling greatly with her mental health, and I think she is misdiagnosed. I think that the professionals deem her to be too young to diagnose what she may possibly have as far as mental health goes. She's got a history of some serious mental health from both the maternal and paternal side. And I think we need to take that into serious consideration when prescribing her meds and when reviewing her treatment plan. I think that that is the root of what is going on with Sarah, outside of all the trauma that she has endured. But I think this mental health piece is a huge component, and we're just missing the target here. And so while our visit was not good, and while she's having all these behaviors, I do not believe it is intentional. I think Sarah wishes she felt better. I think Sarah wishes she could live with a family and be at peace with herself and others. So I want to help her get there. And I think that not only would I like a guardian ad litem appointed, I would also request that we have more serious conversations with these placements and more serious conversations with Sarah on what that would actually look like. How does that compare? How do these placements compare to where she's currently living? Because where she's currently living, it's not like she's at some posh hotel. I mean, the circumstances at these other facilities, just because they're called inpatient, could possibly be more appealing to her. But she can't make that decision if she doesn't know. So I think we need to supply her more information. We need to become more educated as a team as well to help make those decisions. I know that the neuropsych that you ordered previously was never completed because she was moved placements. That is now on the calendar to occur. I know that we've asked Ms. Roden has been very hands-on and helpful. She's reached out to SJRC to have Dr. Coverstone complete a behavioral assessment. We're doing the best we can. I'm open to any ideas, but I think we need more hands on deck. We need more information. And I think that we need to be holding possibly weekly staffings with the department, with their placement team, and with someone with decision-making ability to be on those calls, as long with the mental health assessor or whatever the proper term is for that title. We really need that in place. I'm so concerned for Sarah and her safety and the safety of others when she goes into these fits. So it really needs some serious attention.
Thank you. All right, Ms. Roden, anything else that you want to add?
Yes, sir. I just want to add that I agree with Ms. Swallow. I think we're all really concerned for Sarah. We've had some great conversations where Sarah is so funny and so polite. And then I know that she's also struggling, with the behaviors on top of that. So I think Ms. Swallow was correct in saying we're just missing the mark. And I think Sarah wants to be, at peace, be able to be with family. So I would just be asking that you make in order that the recommendations of whatever that behavioral consultation, I would like to make those recommendations order the court. I know we don't have it yet, but if you could make that so that we know the DFPS and the team will follow through with all of our needs. I also agree that we need to have more information on these placements. And part of the barrier has been that now that she was accepted, not in a temporary bed, but to the RTC, DFPS has not been able to continue the search for placement, is my understanding, in speaking with Ms. Ramos and her PD. And so I'd also ask for an order that they continuously seek placement that's more appropriate for Sarah. The placement that she's in right now is doing a fantastic job trying to work with her, but I think we're just not quite getting her what she does need. We're not seeing really the improvement in the behavior. So if we can continuously seek a different placement, I think that would be beneficial. And then also that we make an order of the court that whatever the recommendations from the neuropsych are be carried out. And that's it, Your Honor.
Thank you. Okay, I've heard what I need to hear as far as Sarah is concerned. So let's go over Nate. May Sarah be excused?
Yes, Judge, thank you.
Bye, Sarah. Good to see you again. I'm glad we got to talk last week. Okay.
Good to see you too. Bye.
All right,
Bye,
take
Sarah.
care.
Your Honor, CASA is also only on Sarah's portion of the case, so may I be excused at this time?
You may. And just for the record, the court did meet with Sarah last week via Zoom, and I did talk with her for a little while with Miss Swallow and Miss Roden present. Let's talk about Nate. Is he still in the same placement, Ms. Ramos?
Yes, Judge, with Ms. Alvarez and Mr. Hill.
Is it safe and appropriate meeting his needs?
Yes.
Is it in his best interest to continue in that placement?
Yes.
Is he up to date on all of his checkups?
Yes, he is. He'll be due for the dental until November. And he's up to date with the physical.
And is he currently receiving any psychotropic medication,
No, he's not.
or his educational needs being met?
So he did complete high school, like I mentioned in the last hearing on June. And he was set to start college. However, he's gonna start in the month of January for the next semester. Right now, he's working.
Okay. Where is he working?
He got a job at HEB.
Does he have any other requirements that he needs to fulfill in order to receive his benefits?
No, Judge.
Okay. And how are his behaviors?
He's been doing well. I haven't had any concerns. I did ask the caregivers and they don't have any concerns with behavior either.
Okay. Ms. Dominguez, any questions about Nate?
No, sir, he's doing well.
Ms. Swallow?
Thank you, Judge. Ms. Ramos, does, since the last hearing where the court authorized Nate to live with Ms. Alvarez, did the department request a home study?
Yes, we did.
Okay, and is the department still requesting a home study?
No, since it was withdrawn by Ms. Alvarez, we don't have an objection to that.
Okay, do you believe that Ms. Alvarez's home would pass a home study?
The home, yes.
Okay, but the circumstances for which we're all aware in regards to a pending investigation, would that be a barrier to the home study passing?
Yes.
Okay, so at this time, we do not need a home study.
No, based on the court order for placement, we don't need one.
Okay, thank you. No further questions.
All right. Anything else that you want to report, Ms. Swallow?
Yes, Judge, thank you so much. Nate is doing really well. He loves his job. He started yesterday. He's working several days a week from 10 to 4. He's extremely money motivated. He has been ever since I've known him. So he's saving his money. And I believe Nate's going to do great things with his life. So he wants to do welding still. He's looking at ACC. They have a welding program. He has his tuition fee waiver. I would request that the court order or at least make a statement as to whether or not we need a home study. I do not believe that we do. I know Nate does not want to inconvenience placement at all. And so, you know, that caused a lot of stress, you know, having an assessor reach out, want to schedule, not returning calls, pushing for an assessment. I got involved. The assessment is put on hold, but this could come up again. So I just want that to be clear that we do not need, I haven't heard a reason why we need it. So that be noted. So I advocate his placement continue. I'm super proud of him. And I think he's on a great track.
Good. Glad to hear it. Well, we'll start with Nate since it'll be quick. Court finds that Nate's, what's his permanency goals? Independent living?
Yes, Judge.
Court finds that his goal of independent living is in his best interest. Court finds that his placement is safe and appropriate, meeting his needs and in his best interest to continue. Court finds that he's up to date on all of his checkups. He's not currently receiving any psychotropic medications. Court finds that he is currently working and will begin school in January. Court finds that it's not necessary for there to be a home study on the home of Miss Alvarez and Mr. Hill. Seems like everything's going really well. He's 17 years old. He can let somebody know if there's any issues. I don't know that it's necessary to trouble them or it's worth a resource. He's been there for a while. Everything's been going fine. So I'm going to order that those court's going to dispense with the necessity of the home study. And then I'll find that this is the least restricted placement available to Nate. Court finds that the placement for Sarah at this time, well, first, let me say I'm going to grant your motion. Substitute Miss Savage as guardian ad litem, remove Miss Swallow as guardian ad litem, maintain Miss Swallow's appointment as attorney ad litem for Sarah. Going to find that her placement is safe and appropriate. However, it does not seem to be meeting her needs. And it does not seem as if it's in her best interest to continue. So I'm going to order the department to continue to search for placements for Sarah. I'm going to order the weekly staffings to discuss her progress and these assessments. I'm going to order that neuropsych get done. I know it's scheduled. I want to make sure it gets done. I've been wanting that for a while. And in these weekly meetings and with any placements that you have, I want there to be some pretty in-depth discussions on her mental health needs. I don't want the focus on what's best for Sarah to be about logistics as much as it is about mental health needs. And she's not going to like it very much, but I'm also ordering that I don't want Sarah saying, I don't want to go there to be the reason that she doesn't get the mental health help that she needs. Otherwise, Ms. Swallow, I think, used the term, we're stuck in a loop. We are absolutely stuck in a loop because what I think is happening is that Sarah does not want to address these issues. And so she's going to continue to say, I don't want to go there. And the department's going to say, okay, well, we can't send her there. Placement's not going to accept her because she doesn't want to be there. We got to stop that. And I know it's not going to make her happy. And I know it's probably going to get worse before it gets better. But I'm concerned. She's 14 years old right now. She just turned 14. We've got 4 more years trying to get her the help that she needs before we send her out into the world. And I think we're going to need every bit of that. So Sarah does not have, this court is taking away her right to say, I don't want to go there. If it's a mental health facility that everybody agrees that the neuropsych evaluator, the therapist, the behavioral evaluator, if everybody agrees, all the professionals who've been doing this and are trained to do this agree that she needs to go to a facility, whether it's locked down, not locked down, whatever it is to get the help that she needs, she's going. I'm ordering it. It's done. So if we find that facility, then that's what we're doing. I think part of the fear is maybe that she's not going to participate or she's going to have outbursts or whatever. She's doing that anyways. She's doing that anyways in a facility where they can't control her. So at least this way, she's going to be getting that intense help that we need her to have. I'm going to order you all to meet weekly. And one of the things I want you to talk about when we get the results of the behavioral assessment and the neuropsych, I'm going to go over those results together so everybody's on the same page. And then I want you to propose an agreed order to the court as to any recommendations that may need to be orders of the court. Ms. Roden asked for the results to be an order of the court, but I don't want to do it that way. I see the point in what she's asking for, but I believe everybody needs to have an opportunity to voice their concerns about it. And if you can all come to an agreement on what that order should look like, then we can propose it to the court and I can sign it if you all agree. Can't agree, then we can have a hearing. Main concern, let me find that her educational needs are being met. She's up to date on all her checkups, her medical reviews up to date. She's passing her classes, education needs are being met. But this continued hospitalization, this has been a problem for a while. And I've met with her for a while, and I know you all know this. And I think that this issue of Sarah kind of running the show on what kind of help she's going to get is why we're still in this feedback loop, and we got to get out of it. Our next hearing is going to be February 6th, 2025 at 10:30. February 6th, 2025 at 10:30. Any questions or clarifications needed on that order?
No, Judge. I would request that we have a progress hearing just to update the court, or the department be required to send, some sort of update to the court. I want to have some serious accountability on this case.
Why don't we do an update to the court? Today is September 5th. Let me get an update on October the 15th. By October the 15th, I want an update on what's happened in her case, where we've moved, what has transpired, what progress we've made. And then at that time, I'll decide whether or not we need to call a progress hearing. Okay. Thank you all for your time and your service. If nothing further, all parties are excused. I appreciate the hard work on this case. It's not an easy one.
Thank you, Judge.
Thank you.
Judge.
Go ahead with the announcements, and Ms. Dominguez, please.
Corinne Dominguez for the department, Your Honor.
Heather Hunt for Belong. April Poulos, Permanency Supervisor with Belong.
Irene Acosta for the kids.
Anyone who's not an attorney or will be giving testimony, please raise your right hand. Thank you. All right, we're here today for a permanency review after final order. We were last here in April, and between now and then, Nikisha has turned 18. I just want to go ahead and start with her. What's the plan right now for Nikisha, Ms. Hunt?
Her primary plan is APLA, independent living.
Okay, so that's still the same.
Yes.
And is she up to date on everything?
Yes, she's up to date on all medical.
All right. Is she still receiving any psychotropics?
She is not.
All right. What is she doing right now?
She actually just graduated high school yesterday. So she has applied to 2 jobs. She has about 30 days to get to keep applying and getting a job, and her placement is helping her to keep applying to different jobs and hopefully get a response back.
Is her placement appropriate and safe and meeting her needs?
Yes.
Is it in her best interest to remain there?
Yes.
And her plan is to stay in extended foster care?
Yes.
Has she been provided with everything she needs in order to maintain that status?
Yes.
Okay. She's still getting to visit with Jesus?
Yes.
How are those visits going?
They're going good. They both look forward to them throughout the week. They're every other week and they are supervised, but they go really well and they're always excited to see each other.
Happy to continue that.
Yes.
Okay. Is she still participating in therapy?
Yes.
You think that's appropriate and needs to continue?
Yes.
Okay. And what about Jesus? What's his goal? Is it still unrelated adoption, or we change? Oh no, it was changed to independent living, wasn't it?
Yes.
Do you believe that independent living is still in his best interest?
I do. And that is what he asked for. So yes.
And is he still at the RTC?
Yes.
Okay. And is that placement safe and appropriate, meeting his needs?
Yes.
Is it in his best interest to remain there?
Yes.
And are both of them in the least restricted placement available?
Yes.
How is Juan doing in school? I mean, Jesus, excuse me. How's he doing in school?
He's doing good. He recently started his 10th grade and he's doing good so far.
So you believe his educational needs are being met?
Yes.
Do you need any other orders today for either child?
No.
And have they both had an opportunity to express their wants and desires as a placement to you?
Yes.
What county is his RTC in?
He's in Hockley, Texas. So the Houston area, I'm not sure which county that would be.
I just know we had talked back in April about possibly getting him closer to home, but I guess we haven't made any progress there. We haven't found anything yet.
He does not want to. He wants to stay in the Houston area
Okay.
because he wants to go to a college or a trade school there.
Okay. These things change fast. Okay. Any questions, Ms. Dominguez?
I'm kind of new to the case, Judge, but I did have one. This child has a medical disability?
No.
No? Okay. So she's not eligible for SSI in any way?
I don't believe so, no.
Okay. That was my only question, Judge.
All right. Ms. Acosta?
Thank you. With regard to Jesus, he also has a friend, Eddie, who lives in the Houston area, correct?
Yes.
And he wants to maintain frequent contact with him, correct?
Yes.
And do you believe that's also a reason why he wants to stay in the Houston area?
Yes.
Okay. And that's a good relationship that he has with him, correct? He visits with him as much as he's able to?
Yes.
Okay. With regard to Jesus also, what needs to happen in order for him to move from this placement to a less restrictive placement?
I would say that he just needs to keep improving on some of his behaviors in the RTC. He does really well, and then he does have some minor slip ups or incident reports.
Okay, and how often are the incident reports occurring?
Honestly, only every couple months, but he also has expressed that he likes his placement and he doesn't want to change placements.
Okay, and have you talked to him about moving potentially to a less restrictive placement in the same area?
I have not. I will be visiting him for the first time this month, and I'm gonna talk to him about looking into some other options.
Okay. Because is it true that it's not in his best interest to remain in a more restrictive placement indefinitely, correct?
Correct.
Okay. Has he also expressed that he wants to continue going to the same school?
He hasn't explicitly said that he wants to stay at the high school. It's more that he wants to stay in the Houston area.
Okay. With regard to Nikisha, has she discussed or has any more information been obtained with regard to her mother?
No, she did. When she turned 18, she did reach out to her mother on Facebook, and they have been communicating a little.
Okay, so she was able to get some type of information for her.
Yes.
Okay. Has Belong attempted to locate or identify any other family members for either of the children to potentially have contact with, since that's something they've expressed interest in?
Yes.
Okay. With regard to Nikisha, what's being done to get her engaged in learning how to drive?
Her placement is helping her start her driver's ed.
Okay, and when will she be starting that?
I believe they said within a month or two.
Is that something that you can follow up on to ensure that it occurs?
Yes.
Okay. And Jesus is 16, correct?
Yes.
Is he eligible to take driving classes at his placement?
I know he has his ID. I can ask his placement if they would help with the driver's license.
Okay, and all right, thank you. Have both Nikisha and Jesus stayed in contact with their older brother, Juan?
Only Jesus has.
Okay, and do you know whether or not they're aware of the incident that occurred earlier in August?
Not to my knowledge.
Okay, I'll pass the witness, Judge.
All right. Anything else from Ms. Hunt?
No, Your Honor.
No.
Okay. Anything else you want to add, Ms. LaCosta?
No, they're both doing well. I would like Jesus's, I know he wants to stay where he is, and I know he wants to stay in the Houston area because he wants to continue being able to visit with his friend. I think that that's a really important connection that he has. And so I don't want to do anything to disrupt that, but I also don't think it's right for him to continue in a facility that's more restrictive than it needs to be for him. So I don't know if there's any other options in the same area that when he is ready to move into a less restrictive setting that he could be moved to. That wouldn't disrupt his relationship with that person because I know that that's very, very important to him. And with regard to both of them, I'd like to see I know with Nikisha especially, she's already 18. She's going to get a job. She needs to learn how to drive. I mean, I want to see that happen for her. I'm glad that she was able to find her mother. I don't know if there's any other information that can be provided with regard to other family members. I was appointed on the case post termination on this case, but while mom was still engaged in a case with their older brother. But I know that the contact wasn't frequent, and I know that mom wasn't very present even in the case. And so it's been kind of an issue getting information about her or contact information, but I know that Nikisha had been requesting that and wanted that interaction. So I don't know if there's just any other family that can be found so that she can have more meaningful interactions with people that she's, you know, blood related to. And then I think that's it. Yeah, I think that's it. They're both doing well. And I know that Jesus's incidents have decreased, so that's why I was asking about, is this really the best place for him? Because I'm not getting emails every other week about, oh, this happened and this happened. It's pretty infrequent. I mean, I think the last thing that happened was a vaping incident, so that's concerning. But I don't know if this is where he needs to be, even though it's where he wants to be right now, if that makes sense. But they're doing well.
Understood. Thank you.
You're welcome.
All right. For the purposes of the permanency review, after final order, the court finds that the permanency goal for Nikisha is APLA. Court finds that her placement is appropriate, meeting her needs, safe, and it's in her best interest to remain there. Court finds that she intends to stay and extend foster care, and that Belong has provided everything to her to help her to continue to do that. Court finds that she's not receiving any psychotropic medication at this time. She's graduated high school, is currently seeking employment. Court finds that she is participating in therapy and that is appropriate. Court finds that Jesus's placement is safe and appropriate, meeting his needs, and in his best interest to continue at this time. However, I am going to order Belong just to start looking at less restrictive placements as time goes by to see if it would be appropriate. You know, if we can move in that direction, then obviously we need to, but I don't want to jump the gun on it either, but I want to keep an eye on it. I agree with Mr. Costa in that regard. Court finds that his permanency goal is independent living, and that he's up to date on his checkups as well. I think you said he's not receiving any psychotropic medication, or is he? I don't know. Maybe we didn't cover that.
We did not. He is not receiving any.
Okay. I wanted to say I didn't think he was from previous hearings. Okay, court will make a finding he's not receiving psychotropic medication. Court finds that the contact between Nikisha and Jesus is in their best interest and orders that to continue. Court finds that his educational needs are being met, and that both of them had the opportunity to express their desires as to placement, and that at this time no other family members have come forward. Next hearing would be February 6th, 2025 at 10 a.m. February 6th, 2025 at 10 a.m. Did I fail to address anything?
No, just Your Honor, I don't know if you can order the follow-up on driver's ed.
Yes. I'm sorry, I forgot that. Yes, let's do that. I'm ordering Belong to follow up with driver's ed. Thank you for reminding me.
You're welcome.
Okay.
Judge, is
Yes.
that for both children? For both,
Yes.
okay,
Yeah, because she needs to drive too.
okay.
Ms. Hunt, have you ever testified in front of me before?
No, this is my first time.
Ms. Harrison Bader Poulos now is your supervisor.
Yes.
Did she teach you how to testify?
Yeah.
Because I could tell that she's giving you some tutelage, because she was always very succinct with her answers as well. And I appreciate that. And you've definitely taken a playbook, a lesson from her playbook. So thank you to both of you for that. It makes these hearings go very smooth. I appreciate it.
Thank you.
You're welcome. Okay, that'll be all. All parties are excused. Thank you for your time and your service. Uvalde County, Texas.
Thank you.
Court is streaming from Kendall County, Texas. Are there any objections?
No.
None. Okay. Then with that, Ms. Dominguez, would you please begin the announcements?
Corinne Dominguez for the department, Your Honor.
Richard Sullivan covering Deborah Fuller for the child. Ready?
Kathleen Savage, attorney for the respondent mother, Mariah Davila. She's present or ready. Miss Davila, if you'll unmute yourself and announce your name for the record.
Okay. Mariah Davila.
Jennifer Harris, attorney for Mr. Dickey. Can you please unmute and say your name?
Dustin Dickey.
Vale Rodriguez, family-based safety services worker for the department.
Colleen CPS supervisor.
Anybody else that needs to announce?
Lisette Reyes, parent educator for the PET program.
We're here for a compliance hearing on the TFF case today. Mr. Rodriguez, how are we doing as far as progress in this case? Let's start with Miss Davila. How is she? Is she in compliance?
She is in compliance, Your Honor. Drug testing has been negative, and the department has had them do the OSAR assessments. She has been referred to South Texas Rural Health, and she's supposed to be making contact with them.
Okay. Is she cooperating with you and maintaining contact? I couldn't hear you, Mr. Rodriguez. You're still muted.
My apologies, Your Honor. He is in compliance and he is cooperating. He has done.
Hang on. I was asking, is the mom maintaining contact with you and is she cooperating with you on a regular basis? Okay.
Yes, she is, Your Honor.
All right. Now let's switch to the father, Mr. Dickey. He is in compliance?
He is in compliance.
Okay. And he's cooperating and maintaining contact with you too?
Yes, he is, Your Honor.
You feel like he's making progress?
He is making progress. Yes, sir.
Right. You believe that the concerns that brought this case before the court are being addressed and that these services are effectively alleviating the effects of abuse or neglect or preventing future abuse or neglect?
Yes, we do, Your Honor.
All right. You believe it's in the best interest of the child to continue this case at this time, continue working with the parents?
The department would like to dismiss the Texas Family First services, and the parents are in agreement to continue with regular family-based safety services.
All right. Ms. Dominguez, do you have any questions for Mr. Rodriguez?
Mr. Rodriguez, so you're asking that this case be dismissed?
Yes, Your Honor. Yes, Ms. Dominguez.
And they will voluntarily participate without us requiring a court order in FBSS?
That is correct.
Okay, thank you.
Ms. Savage?
No questions, Your Honor.
Mr. Well, actually, Ms. Harris.
What are the services that you're asking the parents to complete in the family-based case?
They are to continue with the OSAR recommendations. Ms. Davila will maintain contact with South Texas Rural Health, and they will do their assessment to determine what services are needed for her to address the substance abuse. Mr. Dickey has done his OSAR assessment, and the recommendation was for him to attend NA classes, so he is to continue with that. The department will continue with random drug testing until we can close out this case.
The witness, Judge.
Mr. Salvador?
Yes. How's the child doing?
The child is doing good. I've contacted Avance Head Start, and the therapist is working with him for speech therapy. The daycare has no concerns.
The department has no concerns for the child either?
The department has no concerns with the child either.
Okay. And the parents have been appropriate around the child?
The parents have been appropriate around the child, yes.
Okay. And you believe closing this case, there's no safety concerns at this time?
Currently, there are no safety concerns.
Pass the witness, Judge.
Anything further from anyone else?
No, sir.
No, sir.
Well, then based on what I've heard, it sounds like things are going very well. It sounds like everyone feels moving forward that this can continue without court intervention, and then hopefully close out relatively soon. This is how we perceive these cases going. Ms. Davila and Mr. Dickey, this is exactly how we would like for them all to go, is just to get in and do what we need to do and then get out and handle it outside of court and then address these concerns and then move on. So thank you to both of you for working hard. I'm proud of both of you. I want to give you a round of applause and tell you good job. And then just to keep up that same work ethic that you've got, and in the nicest way possible. I hope I never see you in this courtroom again. And I wish you the best of luck. Anything else that I failed to address?
No, sir.
Okay. The motion to dismiss is granted, and there will be no further hearings. All parties are excused, and good luck to you both.
Thank you.
Thank you.
Thank you, Judge.
Thank you,
Thank you.
Your Honor.
You're welcome.